So you're beginning to get your head around homelessness law. You might have seen a few videos on this channel, you might have done our training, you might have been having a dig around on Shelter's website or look at the LGO decision website, and you're getting a pretty good handling of those basic concepts. What is a homeless application? What's the definition of priority needs? Those key kind of things that are going to be the access point to getting help through the council's statutory duties. And so you're feeling good because the law is generally pretty good. Most people who are homeless will be owed some assistance, and then the rubber hits the road when you actually start putting it into practice with the council. And in order to give an example of this, I'm going to look at some councils I've dealt with only once, because in Bedford, where I've been doing this for 10 years or so, it's not that difficult. There was a lot of resistance back in the day, but these days, as soon as they realise that the fact someone actually knows what they're talking about is approaching them for assistance, and the fact the council know that I'm likely to complain or do whatever if the council doesn't comply with its duties, they're going to deal with clients that I'm involved in pretty well. In most cases, there are obviously some failing still, but it's generally pretty good. But it's a different story if I go to a different council that never heard of me, basically, because they assume that I'm not going to challenge them. They assume that they're going to be able to fob me off and their usual techniques are going to work. And so what actually happens in this situation, you kind of tend to get this pattern of behaviour where you're interacting with the council, you're telling them what the law is a lot of the time, and they'll simply just basically stonewall it, and you end up having to make a complaint to get a good outcome. So a good example of a case that I worked on this year, or finished working on this year, finished up this year, was a family from an area I've never been to, never actually set foot in this area. But basically it was a mum and two kids, and the dad of the kids had been perpetrating very serious domestic abuse for many years. So she was known at Marrick, the mum was known at Marrick, Children's Service were involved. The police were kind of regularly attending, and he was awaiting a Crown Court date because he breached a non-molestation order or something along those lines. And what had actually happened, and I didn't know all this at the start, so I was kind of going on limited information, but that's fine, because if you just apply the basics, you don't need to know everything. What had happened was she'd actually gone to the council's website many years before, gone to the advice page, and basically the council's online form had said, if you're homeless or you've got some housing issues, fill in this form. So she did. Unbeknownst to her, it was the generic Part 6 application form for social housing. But in the course of filling in that form, she told the council very specifically that she was currently at risk of domestic abuse. And for those who are kind of familiar with housing law, if you're at risk of abuse, or if it's probable that the abuse will continue if you're in your home, it doesn't matter if you have your own tenancy or if you're in your own home, you are legally homeless, and therefore the council has a duty to do various things. And because since the Domestic Abuse Act, domestic abuse itself is an automatic priority need characteristic, or if you're homeless because of domestic abuse, it's an automatic characteristic. Basically, councils are going to have a duty to people who are in that situation, provided they've got recourse to public funds. The council's going to have a very substantial duty to provide long-term settled accommodation in almost every case. Obviously there's exceptions here and there, but that's going to be kind of the ordinary kind of way it would go forward. So council knew that she was homeless, and if we just go to 18.6 of the Code of Guidance, I'm paraphrasing it because I haven't got it in front of me, but I'll put it up on the screen. It basically says housing authorities should take particular attention to identify instances where someone has applied to that generic Part 6 kind of pathway, but in the course of doing so, they've given the council reason to believe that they might be homeless. And basically ticking a domestic abuse box in that Part 6 form is almost certainly going to give the council reason to believe that you might be homeless, and it should therefore be dealt with as a Part 7 homeless application, which is the pathway that gives you the interim accommodation duties. So she, the mum had done everything she knew what to do, because she wasn't a lawyer, so she didn't know the ins and outs of it, but she made a reasonable attempt to get assistance. And for years the council had basically done nothing. They kind of messed around, you kind of asking for documents and losing them and asking for again and all that sort of stuff. But basically the key thing is no interim accommodation had been made available. So I found out about the situation. As I say, I only actually knew about the previous kind of 2 or 3 months with the council, so I didn't know about the historic years, but I found all that later. And we can kind of see an email trail here between myself and the housing options officers, or the housing options team that was involved. And again, I'm making sure it's all anonymised. There were some very specific things around this case which would present a danger if the perpetrator found out about it. So I'm going to kind of just make sure there's no way that it could be identified. And if we just kind of basically assume I've sent an email off to the council, I've used my normal kind of formula, this is a section 184 homeless application in the title. And I get this response back on this Friday the 5th of May, back in 2021. And essentially, in that section 184 email trigger, I basically said, what's going on? This person has told you that she might be homeless. Why has no homeless application been accepted yet? And so the response came back saying, hello, at this stage, no homeless application has been triggered. She will need to fill out the homeless inquiry form. Due to the Domestic Violence Abuse Act, which states the safest place for her is refuge, please get her to either contact us so we can explain this to her, or get her Safer Steps worker to source refuge. So I don't even know what Safer Steps is or anything, but we can quite clearly see already that this is written by someone who doesn't know what they're talking about. The Domestic Violence Abuse Act isn't a real thing. It's called the Domestic Abuse Act. We've got this idea that she needs to fill in a particular form, which is very, very unlawful. If we go to 18.5 of the Code of Guidance, again, I'm paraphrasing, but it basically makes the point that homeless applications can be expressed in any particular form and made to any department of the local authority. So there doesn't need to be a particular named form that needs to be completed to trigger an application. The application is triggered as soon as you ask a council for help with housing, and you give them reason to believe that you might be homeless. And you don't have to use the word homeless necessarily to even give them reason to believe, because domestic abuse would be something which almost certainly will give that reason. So the point is, you don't need to know the kind of technical jargon. You can do it any way you want, and you don't need to kind of give the exact wording. So the advice here to fill in a particular homeless inquiry form is just bad advice. They can use forms, sure, but the fact is that people can apply plenty of other ways as well, and the council can't say they must fill in this form before we'll accept an application. That's very clearly gatekeeping. And then the third issue here is that this kind of advice that she needs to go to refuge. Nowhere in the Domestic Abuse Act does it say that the safest place for her is refuge. That's just not true. It doesn't say it in the Domestic Abuse Act. In the Homelessness Code of Guidance, under housing law, under homelessness law, it basically says that refuges are an option, but they should not replace Section 188 interim accommodation. So essentially, they're suitable potentially for maybe the kind of survivors of the most serious types of abuse, but even then they're only short term, so it's not going to avoid those long term duties anyway. So we can clearly see here that this particular officer doesn't know what they're talking about. And you might think that the way I responded is rude, bearing in mind it was already clear that the council were very deliberately gatekeeping her, had already failed her, had left her at risk of abuse where she'd actually gone on to be abused by the perpetrator because he knew where she now lived. And so, in one sense, there's no need to be really polite and fluffy about this stuff. This housing officer has access to Google. They can find out what the law is, even if their superiors haven't told them what the law is. There is no way that a kind of a competent housing officer should be able to make 3 mistakes in 4 sentences. That just shouldn't be how it, that's just not okay. That is a failure. And it's a failure which the individual housing officer is accountable for. It's not just like circumstances. This is their job. They get paid to do this. They should know this basic stuff. So I got back later that day when I obviously got the email, said hello again, just so I can be completely clear about this, as I'll be making a formal complaint to your CEO and will copy in the relevant counsellors if I understand what you're saying correctly. So to summarise, the perpetrator in the situation has already been convicted of breaching a previous non-molestation order and is now awaiting a Crown Court date hearing in February for breaching it again, knows where she now lives and has made contact with her in a way which would clearly cause her distress. You're saying there's not even reason to believe that she may be homeless under Section 177 of the Housing Act 1996. And again, I've just put a bit of technical stuff in there just again to kind of hopefully just like awaken them into the fact that they are actually involved in the legal process. For those who don't know, Section 177 builds on Section 175. So 175 is the kind of the bit of the law that explains how you can be homeless. And the third subsection basically says that you're homeless if you have accommodation, but it's not reasonable to continue to occupy. And one of the big kind of ones on that will be domestic abuse, where you might own your own home, but if you're subject to abuse, it's not reasonable to continue to occupy that accommodation, therefore you're homeless. And Section 177 then makes the point that you're homeless because of domestic abuse if the abuse will probably continue. That's the key thing. It's about, whether on the balance of probabilities, the abuse is likely to continue. And in most cases it will be, because domestic abuse tends to be an escalating pattern of abuse over a period of time. Very rarely will it be a one-off event, basically. So again, I'm just kind of putting that stuff in there just to hopefully kind of awaken them a little bit and just think, oh, hang on a minute, we actually better be a little bit more, kind of diligent here. And what probably happened here is that the frontline officer then went back to their manager, because I then get an email from the manager. So bearing in mind, up until this point, they've not named themselves. So whenever you have a housing options officer who signs off as the housing options team and doesn't give their own name, that's already a bit of a red flag. Because you think, why are they not putting their name on it? What is it that they don't want me to know that that they've said, or hold them to account? So the manager then gets back to me within about half an hour of me sending that email, and says, "Hi Mike, we cannot take a third-party referral, which is why I asked if the client could fill out our homeless inquiry form. An officer will then be in touch to go with them to go through the application, and then we can source refuge for her, as it would not be safe for her to remain in the town due to the perpetrator knowing where she is." So again, that even then, the refuge is not the only option. Basically refuges are very specific types of accommodation, and in my experience, councils quite often use them as a threat to say, oh, there's a refuge up in Northumberland, you're going to have to go up there, as a way of kind of putting someone off from making that application, because councils can absolutely house someone in an area where there is a risk. It needs to be balance of risks, but they need to balance the risk against the risk of being socially isolated, but they can do it. And there will be other types of accommodation which they can secure outside their district if needs be. So the refuge is not the only option, and the LGO did actually make that point within its final decision a bit further down the line. So I then respond back within whatever that is, a few minutes, 10 minutes or so, and you can see here I've kind of lost my patience. This is they're kind of making more and more errors. This is a very serious and very basic bit of the law. This is not something which I'm talking about sort of really like kind of nuanced kind of thing based in 50-year-old case law. This is their bread and butter. This is why they exist, is to help people who are at risk of homelessness. That's why they're there. They're not there to kind of put all these additional barriers in there. And as I say, this is not just ignorance, this is willful ignorance, if at best. I would expect that this housing manager absolutely knew full well what the law was, and was just basically setting this policy or this practice of breaking the law as they went. So the manager had said, I can't trigger a homeless application on her behalf. That's what she's basically saying. And so I just get back straight to her saying, of course you can take a homeless application from a third party. The consent form I copied in explicitly gave authority to do so, which you did. Please read paragraph 18.5 of the Code of Guidance again. Third parties trigger homeless applications all the time, and as I've already said, she triggered the homeless application months ago. It was actually years ago, as I found out later. Section 184 is triggered when someone gives you reason to believe they may be homeless and asking for housing assistance, not when you recognise that. She would have done this in the initial housing register application form. So and on this point of can you make an application on someone else's behalf, there's a paragraph in the Homelessness Code of Guidance which makes this explicit point in the chapter on domestic abuse. And actually I just kind of did a bit of googling, and there's this bit on Shelter's website which kind of makes the point as well. Shelter's website, by the way, is really, really good in terms of kind of pedantic technical legal knowledge. It's really kind of great stuff. So on this page, and you can check out the link if you want. So what constitutes a homeless application? Homeless applications are made to a local authority. Applications can be made by the person who is homeless or threatened with homelessness, or by someone on their behalf. This could be someone acting in a professional capacity, for example, a solicitor, advisor or social worker. It could also be made by a friend or relative if the applicant is unable to make the application for themselves. And as I say, the Code of Guidance actually gives this exact example within domestic abuse, just to kind of labour that point. So you can see the initial kind of resistance you get, and your only option is to plough through it. There is no other option. So basically immediately I made a subject access request on her behalf, and I started the complaints process immediately. And as essentially what then happened was the council messed up the SAR, they delayed giving the SAR, and they then delayed in the actual complaint process. But the good news was, in that kind of mess of me involving the chief exec and repeatedly going back to them, the family were then housed in safe social housing, which is a really good outcome, kind of within months rather than years. I can't remember how many months it actually was. And the LGO, because the council didn't uphold anything as they kind of expected to in this situation, it is because it's a stupid council. Basically, a sensible council would have looked to settle at that final stage, but clearly they just weren't used to being challenged. As I say, this council was in the legal aid desert, so there were no legal aid funded services taking or holding this council to account. And that's often the way things are in my experience. You know, these councils that don't have people chasing them basically just get away with all sorts of nonsense because they can. And that's kind of, and so they kind of get embedded in these practices which are specifically unlawful because nobody's actually bothered to challenge them before. So the LGO got involved, and basically, so given by this point the family's house, which is all good, the LGO upheld a complaint. It made the point that yes, people can make third-party applications on someone else's behalf if they've got the consent, and kind of picked apart various other points of the kind of case and kind of made that, kind of made findings on bits and pieces as well. I don't think there was any point that I raised that was not upheld by the LGO. So yeah, that's kind of, as I say, that's just because it's pretty straightforward legally in terms of what I was saying. So the LGO final decision basically has three aspects to it. So the first thing is that the council should apologise to Miss X for failing to consider whether it owed her homelessness duties to her between 2019 and 2023, because as I say, this family had actually been in this situation for years, and the mum had already applied back in 2019 and the council didn't engage its homelessness duties back then either. And for closing a housing register application in 22 in error, and again that's just nonsense admin stuff. They kind of lost some forms and ridiculous. Secondly, pay her £3,025 to remedy the injustice caused. This is calculated on the basis of 3,000 whatever, so 150 per month from 2022 when she made the housing register application referring to domestic abuse, to 2023 when the new tenancy started, which is a total of however many months that was. A further £500 to remedy the uncertainty about whether the outcome may have been different from the council's fault in 2019, and £300 to offered to remedy the injustice caused by delays in the complaints process. So even the fact the council didn't manage to deal with the complaints in time, that put another 300 quid in it as well. And then finally, the council has provided details of the changes it has made to its processes to prevent recurrence of the faults identified. It's working towards Domestic Abuse Housing Alliance accreditation, which it expects to achieve within 18 months. On this basis, further recommendations are not needed. So you can see, if you kind of look at that initial contact back in the emails back in, when we started getting in contact with the council, and how they would just kind of block everything and everything else like that. Pushed through it, made the complaint, got a house, got a £3,000 compensation, and got the council to commit to meeting these DAHA standards. And I'm told that the DAHA standards are actually pretty good. It's actually quite difficult for councils to comply with those standards. I'm also told that there's no real monitoring after they've actually got the accreditation, so that's a bit of an issue, obviously. But here we can see an example of that's the kind of thing that's involved. There wasn't really much more conflict in the exchange other than that, because I did have to chase the data protection team quite a lot, I think, if I remember. And again, I wasn't terribly patient with them either, because again, it's a legal requirement. But you can see that's kind of what has to happen. Now, I've only ever dealt with this council once, but I'm sure if I went back with someone else, and kind of I got in contact with that manager and say, hey, it's me again, I've got another client who's owed some homelessness duties, you can bet your bottom dollar that they would be taking that much more seriously, and you'll be cutting through that nonsense they were kind of going on about. And I often see that particular council kind of making a big show of how great they are, and I'm like, no, I know the truth, you're not. But anyway, another issue. But you can see, using this same technique in Bedford 10 years ago, and having to kind of fight through those initial bits of resistance, you can actually see that over time you just get to a point where it just becomes easy. This is kind of what the point of this video is really saying. Once you've learned the basics of housing law, the most difficult battle you will then have is the first one with the council. That's how it is, and as you can see, you have officers who are just blatantly not following the law, and your only option is to escalate it and take it down that formal route. Anything other than that, in my experience, doesn't work. And I've used this technique or strategy or whatever in many different councils, and it's the only way I've actually found to kind of get councils to actually do what they should do. In most cases, I'm trying to think off the top of my head, in most cases I've actually had to go down the complaints route. So sometimes going to the chief executive in first instance is enough to actually kind of get them to wake up and do what's right. But in this council's case, even that wasn't enough. They still continued to break the law for about a year or so, in terms of actually kind of not housing her. So yeah, that's what it takes. But once you get that first victory under your belt, it all becomes much more easy. And for that reason, I'd say, if you're looking to push for changes in your local area, you're looking to get people housed as they legally should be, you want to wait a little bit for those kind of really clear-cut cases. Domestic abuse is legally clear-cut. There's no kind of doubt. There's no grey area. This family were owed a duty many years before. Whereas if you were to kind of pursue one of the more difficult arguments around unreasonable to continue to occupy, for example, using the Lomax kind of idea about impact on mental health, for example, it can be done. And in Bedford, I've done that without a solicitor. But it was because I had so many upheld complaints under my belt that the council were really looking to take that seriously. If I was to kind of wander into a council and try and make that argument straight away, it'd be very little chance of getting a successful outcome. So you want to kind of keep your powder dry, if that's the right expression. Wait for those cases which are just obvious. There's obvious evidence that the council gatekept someone. I've had complaints go on before where, you know, there was no written evidence of what happened, and often that means it won't be upheld. So ideally you also want complaints where it's just obvious in writing. So in this person's records, you could see where when she'd approached the council through the Part 6 form, that she told them about the domestic abuse, and then that nothing happened. So it wasn't difficult to show the LGO that the council had broken the law. So hopefully that's all helpful. And I guess I don't know what else to say that would be helpful in this situation, because I know a lot of people get their heads around the basics and then they come up against these horrible I mean, this officer wasn't horrible really. She was breaking the law, but she wasn't being an absolute bully. You will get bullies sometimes in these roles, and they will be quite unpleasant. Certainly when I was working at the Drug and Alcohol Service in Bedford Borough Council, someone up high in Bedford Borough Council rang up my boss in the Drug and Alcohol team to try and get me sacked, basically, to try and say, well, why is Mike getting all these people housed? It's not his job, because wasn't my job as kind of recovery practitioner at the time. So, and my boss was cool, so kind of shrugged it off really. But they will try these dirty tricks. Housing officers who are willing to break the law and leave vulnerable people housed are the same people who use dirty tricks against you to try and kind of put pressure against you to do it, and so to kind of not stop doing it. So I don't know how to kind of explain how to get through that other than just digging in. I don't know what else to kind of say that would help you out in that situation. It's really fucking horrible, there's no doubt about it. That experience, certainly in the first couple of complaints in Bedford, I was really doubting my sanity, because I was reading what it said in the law, I was seeing what they're doing in practice, and they're kind of saying, the big wigs in the council saying, we always follow the law, why are you causing trouble? And so you do kind of have that journey of like realising that actually, no, you are right. And once you get a few of these upheld complaints under your belt, you'll feel better in that way as well. So yeah, it's absolutely worth the effort. And it doesn't take more than just some very cursory knowledge about the Housing Act and just a bit of resolve, and just kind of, for me, it was the fact that I liked the people I was trying to support. It wasn't difficult. It's like, they're good people. They needed a bit of justice, and so it wasn't difficult from that point of view, just to kind of stay motivated and kind of try and stick at it until we got a good outcome for lots of different people. So yeah, so I hope that's helpful. I'd be very interested to hear from people in terms of what else it would be helpful for me to say, or information that would be helpful to share, to try and equip people and I guess inspire people to go and take those challenges to the council. Personally, I don't feel sorry for housing officers at all, really. There are some good housing officers out there, don't get me wrong, but ultimately, they might be a good person, but if they're going to work and they're leaving victims of domestic abuse in those situations, then that's not defendable. That's not that's just not, it's not okay. There's lots of things that housing officer can do to make sure that doesn't happen, and unfortunately too many of them get browbeaten and just kind of accept that as the way things are, and it's not. As we've seen in Bedford TA stock for single homeless people has gone up by about 5,000% since we started challenging them. It's absolutely a political decision, and it's absolutely possible for a small number of people to get these big, kind of big changes in local policy. So yeah, if you're out there and you're struggling, I feel for you. It's hard work to push through these things. If you've got any questions around that, let me know. But it's worth the effort. So yeah, hopefully that's helpful rather than kind of anything else. I do hope that's kind of gives you a bit of kind of bit of vision as to what you can achieve.